Hello, and welcome to the 10-Minute Mentor Project, presented by the Maryland State Bar Association's Young Lawyers section. My name is Dolores Dorsainvil, and I'm here to talk to you about ethical considerations in running an effective law practice. My practice area includes legal ethics and attorney disciplinary work. If you are considering starting your own law practice, the first thing you want to think about is starting and opening an appropriate attorney trust account. And if you have any authority over your trust account, whether you are in a partnership or a solo practitioner, you want to make sure that you are familiar with the rules as they pertain to attorney trust accounts. Now, when I say rules, I am talking about the Maryland Lawyers Rules of Professional Conduct, Rule 1.15 in particular, that deals with safekeeping of property. As we all know, the failure of a lawyer to keep their funds separate from entrusted funds or funds that belong to a client or third person can result in either a lawyer commingling situation or a misappropriation. And this is important to know because in Maryland, as with every other jurisdiction in the country, intentional or reckless misappropriation is a disbarable offense. A commingling situation is worth at least a suspension in the state of Maryland. So it's important that you read all the subsections of Rules 1.15. There are rules that also work in conjunction with that rule, particularly the Business and Occupations Professions Rule 16-601 et sec. And those rules have additional requirements for lawyers as they pertain to attorney trust accounts. One of the subsections of those rules deals with how it is that trust account is to be titled. So, if you are a new lawyer and don't have any experience with attorney trust accounts, it's important to know that your trust account has to be titled properly. And having the designation of, attorney IOLTA account, and IOLTA stands for Interest on Lawyers Trust Account, would be considered a direct violation of that subsection of the rules because there are only 3 appropriate titles for attorney trust accounts in the state of Maryland. And that is either attorney trust account, attorney escrow account, or a client funds account. So that's important to know. Additionally, under the 16-601 et sec rules, there is a subsection that effective January 1, 2007, the Court of Appeals has adopted and amended this subsection to state that it is now a mandatory requirement for lawyers in the state of Maryland to keep complete and accurate records of entrusted funds and all transactions as they relate to those entrusted funds. So in addition to the monthly reconciliation that is a required part of Rule 1.15 and the Business and Occupations Professions, a lawyer has to make sure that they maintain and preserve for a period of 5 years following the termination of a representation any and all records that pertain to entrusted funds. Now, when I say any and all records, you're probably asking, what does that mean? That means canceled checks, client ledgers, bank statements, any transaction that will illustrate any deposits or withdrawals in and out of your attorney escrow account, and at each and every point in time as it relates to each client matter. Now, as a practical matter and from a bar counsel perspective, it may be even more prudent for an attorney to maintain those records for longer than 5 years as required by the rules, only because bar disciplinary complaints don't have a statute of limitations. So if you are faced with a bar counsel complaint 10 years after the fact of a representation that has already resolved and concluded, you want to make sure that you are in a position where you can properly defend and explain to a bar counsel pursuant to their inquiry, what happened to entrusted funds at any given point in time that they were in your possession. Additionally, one last thing as it relates to attorney trust accounts, you want to make sure that the only funds that you maintain in those accounts are funds that belong to either a client or third party. At any point in time that you have earned any of those funds are to come out of your attorney trust account and into either your operating account or your personal account. You want to make sure that you do not create a situation whereby you have commingled any funds that are earned, because once they become yours, they no longer belong in the attorney trust account. I'm going to switch gears a little bit, and as it relates to fees and how you generate those funds from clients, another important aspect of the attorney-client relationship is the fee agreement. And the fee agreement is dictated by Rule 1.5b of the Maryland Lawyers' Rules of Professional Conduct. And although in the state of Maryland a writing is not mandatory, it is certainly very wise for an attorney to memorialize their agreement with regard to the representation in writing. Now, one of the things that you want to make sure that you do in this writing is that you set forth the scope of the representation. So whatever it is that you have agreed to do in terms of providing legal services to the client, and it's a good idea to be as detailed as possible. You want to avoid a situation where if your retainer agreement is too vague, there may be a misunderstanding on the part of the client as to what it is that you are going to provide in terms of deliverables. So if you have been hired to file certain applications in an immigration matter, it would make sense to specifically state what those applications are, and that you are to file them, and that you might even want to say something like you won't handle any appeals in the event that the request, in the event that the relief requested is not granted. So it's always a good idea to be very specific. The second part of the retainer agreement that is equally important is that you want to set forth what your fee or the basis of the rate of the fee is. So if you are doing hourly work, you want to set forth that this is your hourly rate and this is what you expect to be paid. Likewise, if you are doing work, either flat fee or contingent fee, and contingent fee in the state of Maryland, it is mandatory that it is in writing. Or if you're doing a hybrid of some of those, or if you're paid by statute, if you're doing probate work, you want to set forth how it is that you expect to be paid. And it's a good idea to be very specific with regard to this aspect because you want to avoid your client having sticker shock. There's nothing worse than a client receiving an invoice for a bill and they weren't expecting to see that number. So during the initial consultation, it might be a good idea for the lawyer to either give an estimate as to the amount of time that it will take, especially if you're billing on an hourly rate, and talk to the client and have a very frank and honest conversation about your expectations as a lawyer and how you want to be paid. At that time, it's also a good idea to gauge the client to determine their ability to meet your expectations. And in which case, if the client is not able to pay your fee or pay your rate, you may want to consider or reconsider undertaking that representation. There are several great resources as it pertains to law practice management and how to effectively run your law practice. I've only covered two in this presentation, but if you are a member of the Maryland State Bar Association, you certainly want to make sure that you contact the Law Practice Management Office. And it's run by Pat Yeviks, who does a wonderful job, and she can certainly steer you in the right direction as it relates to technology and different databases and all types of resources and information that a lawyer would need in terms of running a practice. Some of the things that you may want to consider, especially if you never want to come in the crosshairs of a bar council complaint, is to read the disciplinary matters that come down from the Court of Appeals. They're all listed on the Maryland Court's Judiciary website, and they are an invaluable resource for attorneys to actually learn what the court's trends are and what the court's views are, especially as it relates to such actions as misappropriation and dishonesty, which in the state of Maryland almost always ends with a disbarment. Another great resource is the Maryland State Bar Young Lawyers section website. You may want to visit the website to get information on podcasts of previous continuing legal education seminars, as well as to learn about upcoming legal education seminars and events that would connect you with other similarly situated lawyers who may serve as another great resource. And if you're looking for a mentor, someone to guide you in the right direction, especially if you have questions about running your practice, you certainly want to contact the Maryland State Bar Association, as they do have a bar mentor program, and they can put you in touch with a seasoned lawyer who will guide you throughout the way. So that concludes my presentation, but I would certainly encourage you, if you are a young lawyer, to follow us on Facebook, LinkedIn, and Twitter, or visit our website, www.yls.org. Good luck in running your practice.